Okay, good morning and welcome everybody. This is our Spotlight webinar on insurance. This topic is the fifth of our series of webinars. Our webinar series places topical matters and leading industry lights under the spotlight. We will have time for questions and answers at the end of this session, so please feel free to type your questions into the Q&A area. And there will also be a recording uploaded onto our YouTube site at some point in the next week. By way of introduction, I am Damian James and I act as a delay and quantum expert in the UK, the Middle East and Africa. I supplement my practice by acting as a dispute resolver in adjudications and arbitrations, and also by lecturing with certain academic institutions. I am absolutely delighted today to have with me two leading lights in international construction law disputes. Firstly, I would like to introduce to you Athena Markides. Athena is a barrister at Crown Office Chambers in London. She has particular expertise in insurance, commercial litigation, construction and property damage. Athena is described by Legal 500 as very bright, extremely conscientious and hardworking. She picks up issues and absorbs large volumes of information quickly and provides accurate and timely advice. My second guest is Mr. Bryn Hodges. Bryn is a partner in the professional and commercial disputes team at Clyde & Co. He has an experience of contentious professional indemnity claims and advises on a wide range of coverage issues and disputes. He also has significant experience of litigation in the High Court and the Technology Court. Today we look at insurance and the current challenges faced in the construction industry by employers, contractors, subcontractors and professionals. And while some businesses and industries were impacted by COVID-19 more than others, they all had to adapt. Fortunately, while construction was considered an essential business in most jurisdictions, the industry did, in the main, perform quite well in 2020. However, as construction companies look to 2021 and beyond, some are looking forward to a solid period given current backlogs, while others see their backlogs decreasing and are placing future projects on hold. When this is considered in the context of financial planning, insurance remains a major expense for most companies. And if the challenges of the coronavirus were not enough, the insurance industry itself has also taken a turn for the worse. Although not across all lines of insurance, but in general, rates have and continue to trend upwards. And in some cases, the trend upwards is rather severe. So questions today are, what can construction companies expect beyond 2021? And we are going to debate that with our two esteemed guests. Well, insurance rates have been flat or declining for years due to increase in losses and poor investment returns. Rates for most lines of coverage are increasing. Capacity is declining and underwriters are being more selective on which accounts they will even consider. Determining and budgeting where the rates will go beyond 2021 is at best an educated guess. It now appears to be the case that every insurance account is underwritten individually, and the pricing will be ultimately determined and affected by risk control strategies and the company's loss histories. And we're going to talk to those risk control strategies shortly. Not only has the construction industry been subjected to the burden of the pandemic's financial effects, with rights and remedies under many contracts, has resulted in an entitlement to time and no money through the force majeure provisions following the pandemic. This came in the immediate aftermath of the Grenfell tragedy, when a greater emphasis has been placed on contractors, subcontractors and designers to ensure the compliance of design and installation in construction projects. Thankfully, we have two of the industry's leading lights to provide clarity on all of these issues and more. So I do encourage you to raise as many questions as you can and to place them in the Q&A section of the portal. Athena, if I may start with you, thank you very much for joining us today. I know your time is precious. There has been much talk of the Alliance case, and for those outside of the UK, this case was a matter before the Supreme Court dealing with business interruption. Maybe for the benefit of our guests, are you able to give a brief summary of developments on the insurance front in general?
Damian, first off, thank you so much for inviting me. It's a real pleasure to be here today. Now, you've asked me for a brief summary of developments on the insurance front, which is lucky for everybody here because this is a topic which we could easily talk about for weeks. Although COVID has had a suspensory impact on most aspects of our lives, in the usual counter-cyclical fashion, litigation and the insurance litigation market in particular have seen a real boom in activity. So from the moment that the government started restricting activities, businesses have suffered losses and they've turned to their insurers to cover them. No one really saw COVID coming, so there will have been very few policies which were specifically intended to respond to something like COVID and the related government shutdowns. But the legal test for cover isn't whether the parties subjectively intended for COVID to be covered, but rather whether the ordinary and natural meaning of the words used in the policy is capable of providing that cover. So, as you all know, business interruption, or BI insurance, potentially covers loss of profits and additional expenses which an insured suffers as a result of damage to physical property. But many policies also have extensions which will provide for cover for matters other than physical damage. And it's clauses of that type which came sharply into focus as a result of COVID. And these clauses were the subject of the FCA test case, which you've referred to as the Allianz case, which had its first outing in the High Court of England and Wales in June last year, and which was heard by the Supreme Court on an expedited appeal in November last year. Now, I'm going to very briefly highlight some aspects of both judgments because they have very much set the stage for where we are now. And they are both particularly important because the judgments didn't consider precisely the same issues and clauses. So, looking at the High Court case first. In September last year, the High Court handed down its judgment in the FCA test case, and that case considered whether 21 sample wordings from 8 insurers would provide cover for COVID and the related shutdowns. The FCA was advancing the claim on behalf of policyholders, most of which were small to medium-sized businesses, and there were 2 related groups of policyholders who acted as interveners. Now, the intention was that the judgment would provide guidance on the proper operation of cover under non-damage BI insurance extensions. It was estimated by the FCA that in addition to the particular wording in dispute in that case, around 700 types of policies across 60 different insurers and 370,000 policyholders could be affected by this case. So, well, this is a really big deal. There are 3 main categories of clauses which the court considered. The first is disease wording. So these are clauses which provide cover for business interruption as a result of the occurrence of a notifiable disease within a specified radius of the business. The second category of clause are prevention of access public authority type wordings, which apply where there's been a prevention or a hindrance of access to premises as a result of government or public authority actions or restrictions. And the third category of clauses were hybrid clauses, which operate where there are restrictions on the use of business premises as a result of a notifiable disease. Now, within each of those 3 categories of clause, there were subtly different forms of policy wording. And we don't have the time today to unfortunately thoroughly discuss all of the conclusions which the court reached on each of those 21 forms of wording, but there are 2 key high-level points which I want to flag. The first is that different conclusions were reached in respect of the different forms of wording within categories as well as between categories. So just because there was, say, cover under some disease wording according to the High Court judgment, and you have a disease extension in your policy, it doesn't necessarily follow that you will have cover too. There are key nuances in the wording that need to be carefully evaluated. And the second key point is that the court found that prevention of access public authority clauses were generally to be construed restrictively and more restrictively than disease clauses. And that's particularly relevant today, since the interpretation of some of those clauses wasn't actually appealed to the Supreme Court. 6 of the 8 insurers appealed the High Court decision. Judgment was handed down by the Supreme Court in January of this year, and the 6 insurers had appealed on multiple different issues. Again, the judgment is highly nuanced, it's 114 pages long, but there are some very high-level points that we can draw out of that judgment as well. First of these is that notifiable disease clauses and hybrid extensions were generally found to respond to the effects of the pandemic, although it's interesting to note that disease clauses were construed slightly more restrictively in the Supreme Court than they were in the High Court. The second key point is that policyholders whose business suffered only partial closure rather than a total closure due to COVID-19 may now be able to make a claim for business interruption under prevention of access and hybrid clauses. Again, it will depend on your specific wording. Third key point, some policyholders will be able to claim from the date of government advice earlier in March 2020, rather than from the date the government regulations came into force on the 21st or the 26th of March. And finally, the fourth key point is that the Supreme Court overturned a case called Orient Express and Generali, which up until then had been the leading case on concurrent calls. that the very short point here is that where you have a BI loss which arises from both an insured and an uninsured cause, each of which is sufficient to cause the BI, so true concurrent causes, then provided that the damage caused by the uninsured peril is not excluded, the loss that results from both causes operating concurrently is covered. So the courts are no longer taking a but-for approach to causation, where you have concurrent causes in relation to these insurance clauses. So overall, the Supreme Court judgment is broadly positive for policyholders, but ultimately whether you personally have cover will turn on a very careful consideration of your policy wording, likely in light of both the High Court and the Supreme Court judgments.
Well, thank you, Athena. That's a rather illuminating and interesting response there that you've given us, and I'm sure it's of great interest to many of our attendees. And I think the key takeaway from that is obviously the consideration of your policy wording in light of both the High Court and the Supreme Court judgments. I want to come back to this subject a little bit later on, but I'd like to bring Bryn in now, if that's possible. Bryn, you and I, we've chatted previously and we've discussed insurance in the construction sector. And obviously construction dominates the practices of many of our attendees today. As much as I like two-part questions, I'm going to challenge you with a two-part question. So the first part of my question is just what is the status of the insurance market at present? Has there been an increase in premiums in general? And secondly, and I don't particularly want to limit your response to construction on its own, but how have the tragic events of Grenfell, which we've had a discussion before, and the description of the epitome of poor building was used, how has that changed the insurance market, and how are renewals of policies responding in general? And that's across the whole of the construction sector. Remember that we have employers, contractors, subcontractors, and design professionals with us today.
Okay, thanks, Damian, and good morning to everybody. Dealing with the first question in relation to the general position of the market. So whilst there are many different types of insurance applicable to the construction industry, my particular specialism is in relation to professional indemnity insurance. I think all those who have purchased professional indemnity insurance in recent years will have seen an upward trend in premium, and frankly, potentially a quite substantial increase in those premiums. This is a process that started actually before the significant market losses arising in the wake of the Grenfell tragedy and the pandemic. If you'll indulge me a little bit, going back in time to the immediate post GFC period, insurance seemed a relatively attractive option for capital that had lost a number of its natural outlets. Posting an annual return of over 7% in any decennial period meant insurance was a relatively safe, if not high yield place for capital. This resulted in an excess of capital and competition for premium. Effectively, more cover was provided on ever widening terms and for less premium. That was an unsustainable trend, not least in relation to professional indemnity, where the losses did not strike until some time after the GFC due to the long tail on claims. Lloyd's, the insurance regulator, instituted a review called the Decile 10 in 2018, and that had a material impact on the availability of capital and the appetite for professional indemnity business. Quite simply, for every £1 that was being taken in premium, insurers were paying more than £1 in claims. That review identified professional indemnity as one of the worst performing subclasses. And as a result of this and the increased regulatory burden to demonstrate a return to profitability, a number of syndicates exited this class of insurance. The syndicates that were still open for business were being extremely cautious in their underwriting approach and their deployment of capital. As capacity left the market, premiums naturally increased. All Lloyd's syndicates are allocated a yearly premium pool known as a stamp capacity, and that places a limit on the amount of premium that they're allowed to write. So once a syndicate reaches their stamp capacity for the year, they'll cease writing business. That obviously, as premiums increase, their opportunity to write business obviously decreases. So the upward trend in premium has only been exacerbated by the increased losses arising from the Grenfell Tower tragedy and the pandemic. So my firm has recently completed a survey of the insurance industry, particularly professional indemnity insurance industry, from buyers, vendors, and intermediaries to ascertain the trends that we're all witnessing and those that we're predicting in the future. So I'm sworn to secrecy in relation to the results of that survey, and been threatened not to release any spoilers of what will soon be a campaign by my firm to share our insights on the results of the survey. But I think I think I can share with you a few nuggets. And it's fair to say that for purchase of insurance, it doesn't make happy reading. It will come as no surprise that the results of that survey show that the vast majority are expecting premium increases of between 10 and 20% over the next 12 months. Overall, the market response indicates that the amount of construction business written will reduce and the market will continue to harden through the next year. The three biggest factors driving these trends are estimated as being insolvencies and macroeconomic conditions, cyber and ransomware attacks, which are more relevant to the whole of the professional indemnity market than the construction industry specifically, but it still applies, and increased regulatory burdens. Unsurprisingly, the prediction is for an increase in claims activity in the next 24 months, and this is all driving the increase in premium. So turning to your second question, Damian, which was more specifically geared towards Grenfell and the effect that's having on the market. I've already touched in my first part on the macro effect that increased losses and the consequent withdrawal of many insurers from the market have had on premium. But more specifically, there's been a substantial reduction in available cover for fire safety in the wake of the Grenfell tragedy. Many clients of mine have had the ability to conduct work involving cladding and related products removed completely, to the extent that they've been unable to complete remedial works because they're no longer insured to do so. Where cover has been provided, substantial restrictions on the extent of that cover have been implemented, such as exclusions for indirect losses, large excesses, and the imposition of small sub-limits. And they're all common features of this type of insurance now. It's my experience that the various fire safety exclusions in the market can be very broadly drafted. These can include all claims involving fire safety, not just those related to cladding, insulation, etc., and not those just related to the external wall. This is perhaps an unintended consequence of the broad drafting, but we're increasingly seeing that reviews of external facades spill into consideration of internal fire safety, such as fire doors, partitioning, etc. And potentially these losses will be excluded by many industry fire safety exclusions. So perhaps it was broad drafting, or perhaps it was a moment of apposite crystal ball gazing by underwriters.
I think what you say raises a number of issues there, Bryn. Obviously, the PI insurance. I was speaking yesterday with a colleague in the construction sector who's heads up one of the trade associations, and he was seeing a decline in his members taking out PI insurance just because the very issue that you say there. I mean, it's resulting in multiple claims, and they don't feel well equipped to actually deal with the issues that they can't actually cope with. Quite an interesting stat in terms of the money there, and I think that's quite remarkable. I want to come back just shortly to Grenfell and a little bit in terms of challenging you in respect of the consultant teams, design teams, and respective negligence claims, etc. So I just want to return to Athena now, just pick up on a couple of points which are of interest to a number of our attendees today. So Athena, obviously in the aftermath of COVID and Grenfell to some extent, I expect, I mean, obviously a lot of my work is done in quantification of damages. I expect there are going to be challenges to supporting claims for what you would call direct physical loss in the insurance sector, and how that term ought best to be defined. I don't think we should necessarily debate that, because that takes us into the legal ambit of the testing of those words. But for those that are covered, the first part of my question is, are the issues of quantum and time dealt with differently in any way where insurance disputes arise, or are the principles generally the same? And I think then obviously leads me into my second question, which goes back to your first response. For those businesses with claims outstanding, they understandably want their claims settled quickly. Do we have the necessary clarity in the insurance industry that provides clarity for policy wordings? And I know obviously relating to the airlines question, we've answered that a little bit, but where cover may have been in question, or do you now expect further test cases on issues such as direct physical loss, etc.?
Great question. I think I'm going to take those questions in reverse order, because I think the second one flows on from what I was discussing previously in terms of the test case. I mean, you're absolutely right that although the test case has provided some answers, there are definitely outstanding questions. Prevention of access clauses are an obvious area of potential debate. As I said before, the High Court found that some prevention of access clauses didn't respond to the pandemic because they were intended to respond to specific localized events like gas leaks and bomb scares rather than systemic events like COVID. That wasn't appealed to the Supreme Court. So there is ongoing discussion now as to how the High Court's interpretation of those clauses can be reconciled with some of the more permissive aspects of the Supreme Court's judgment on other clauses. There are also some issues which just weren't considered by the Supreme Court at all. For example, we don't know what constitutes a single loss, event, or occurrence, and therefore how many losses, events, or occurrences an insured has suffered for the purposes of liability sublimits and deductibles. The test case also didn't look at infectious or notifiable diseases clauses relating to losses caused by the occurrence of disease at the insured premises, rather than within a specified radius. So at the premises clauses are also an outstanding hot topic. And finally, the test case only looked at policies providing traditional BI cover, so cover for loss of profit and increased costs of working. And as you know, there are a huge range of losses which may be covered by insurance extensions, like cover for lost rent by landlords. Those policies weren't considered by the Supreme Court. They're likely to raise their own particular considerations. Now, some of those questions may be answered without further litigation. Crucially, it was agreed that the FCA and insurers and the Supreme Court would work together to agree a set of formal declarations, which would then be handed down by the Supreme Court. And those declarations are intended to capture the decisions of both the High Court and the Supreme Court and to provide clear guidance or clearer guidance on how different clauses should respond to losses arising from the pandemic. Those declarations have not yet been handed down, although they haven't yesterday. So if they have, then apologies for missing that. But that's definitely a space to watch for anyone who is wondering whether they might have a claim. But very briefly, I mean, even since the Supreme Court test case, we've seen one further concluded test case, and there's at least one more ongoing. The concluded case is one called Rockcliffe Hall, where the insured argued that the infectious diseases extension in its policy with travellers included cover for COVID-19 because it had a specified list of 34 notifiable diseases which were covered. And it said that COVID fell within the definition of plague, which was one of the diseases on that list. That was a novel argument. The Supreme Court hadn't heard it. The High Court disagreed and the claim was struck out. Another test case of which I'm aware relates to the topic I discussed previously about at the premises clauses. This is a claim by the hospitality group Corbyn and King, and they're looking at non-denial damage of access regarding action taken by a statutory body in response to a danger or disturbance at the premises or within a 1 mile radius. So that case should hopefully clarify a few of the outstanding issues which we've already discussed, because it touches on some of those questions left by the original High Court judgment in the test case. So it is undoubtedly the case there are issues which are not yet completely settled. I think we should expect to see some further trips to the High Court, but hopefully the declarations will also enable us to progress many of the claims which are outstanding at the moment. Now, in terms of your first question, which was, are the issues of quantum and time dealt with differently in any way when insurance disputes arise, and are the principles the same? You'll be happy to hear I've got a short answer for you on this one. These aren't questions which were thrown in for consideration in the test case. The starting point is that traditional principles of policy interpretation will apply. So every insured will have to look at their particular policy to determine the measure of loss and what exactly they're entitled to as a result of any one insured peril. Does that answer your question?
It does, yeah. Thank you very much. Very clear, and obviously some further challenges and further developments to be seen. And I couldn't keep up with the cases that you mentioned there, so I will watch back on YouTube just to make some proper notes against what you just said there. So thank you very much.
Absolutely.
If I can come back to you, a couple of questions really again. In the post-COVID and Grenfell areas which you've just spoken to, what are the common mistakes people make or will make, and I suppose that's the most important part of that question, in relation to the obligations and duties in construction insurance? And the second part of my question is that, given that your firm is an international practice, do you think that the issues of defective work similar to Grenfell will extend? They may already be extended, but do you think they will extend into other jurisdictions in respect of the law and interpretation of the indemnity policies? And what effect could this have on international projects involving international companies? And I say that because obviously from an international perspective, there's a number of our attendees today who will work in one country under one jurisdiction. So it's a Kenyan jurisdiction, but they're working for a Spanish company who are in a contract with an English company. Where do you think that will sit in the future?
Yeah. Okay. So I'm not convinced that there are specific subsets of mistakes that unite the pandemic and or Grenfell. The errors that will be made in future in relation to both design and workmanship will remain those that have always been made and encompass a very broad spectrum. Having said that and made that position statement, I'm now going to argue the complete opposite, or at least try and find something that's useful for those who are watching. In that, I suppose the biggest category of common issues that unite the Grenfell type of claims, and for that matter, the much of the pre-Grenfell claims that I see, is value engineering or pressure on price. It is the single biggest cause of design failure and or inadequate specification, and for that matter explains a number of workmanship errors as well. This is an issue that insurers are acutely aware of and are trying to find solutions to, as the market does not want to underwrite commercial risks associated with the underpricing of contracts. The second biggest theme, in my opinion, is taking responsibility for the content of the employer's requirements, which frequently, within the context of what I see, which is where things have already gone wrong, contain errors or impose obligations that are impossible to meet and still also comply with the contractual duty. A separate category of errors are the errors that are made when contracting regarding apportionment of responsibility and or appropriate limits on the scope of the duty owed. In the post-pandemic and Grenfell world we live in, there have been numerous examples of disputes arising because of a failure to unambiguously allocate contractual responsibility and or to limit the scope under the contract. These are less common in relation to issues and matters that are overt at the time of contracting, but are much more common in relation to known unknowns at the time of entering the appointment. In terms of the international dimension and the jurisdictional issues that you speak to, Damian, regulation in relation to fire safety is always varied country to country. And indeed, that's one of the reasons why we have the particular pickle that we're looking at in the UK. Similar issues to those experienced in the UK are also being seen in Australia and, as you'll probably know, the Middle East. I'll focus on these, but in respect of other jurisdictions, I do not necessarily anticipate that the same level of focus, subject to what I'll say about multinational companies being written out of particularly the UK and Australian jurisdictions. How the UK, Australian and Middle East markets have responded depends slightly on their exposure. And by that I mean the regulatory regime governing the building works, but also the extent to which the insurance is written domestically rather than via Lloyd's in the UK. The high-profile fire relating to the address building in Dubai is, to the best of my knowledge, yet to reach a conclusion. But my understanding of how that claim is progressing, which is generally in the favour of the construction industry, can be contrasted quite starkly with the judgments in relation to the lacrosse fire in Australia. There are a whole host of different reasons for this, including the regulatory regimes, the statutory controls on building works and insurance regulation, and the claimant culture. But the upshot of this is, and reflecting Lloyd's overarching ability to be agile, is that there is no hard and fast rules. That said, my experience is that construction companies completing fire safety work in the UK and overseas are likely to be subject to a version of the fire safety exclusion endorsed onto most, if not all, policies I've seen written domestically. The trigger for that exclusion varies, but often relates to claims arising from an alleged failure to comply with the relevant regulatory regime in relation to fire safety, wherever in the world that is.
Brilliant. Thank you very much. Thank you very much. I see we've got an international question coming through, which maybe you can have a look at before we take the question towards the end, Bryn, if that's okay, because it's a very good question from Uwe. Athena, I want to sort of lead us into a discussion in respect of risks and management of risks, etc. But before we do, you know, from what I understand from both you and Bryn, the global pandemic has left some long-term scars on the insurance market. Is it fair to say that pandemics will not be part of insurance cover? Is this a risk to be carried by the company seeking insurance? What do you expect to see from a market perspective in that extent? Do you expect contractors to shift risks of pandemic or to accept risks of pandemic? Do you expect employers to do that? And importantly, what next then for companies looking for insurance? Because that's a big question for the owners and the commercial directors of our attendees today.
I think
And I guess, again, sorry, just before, I mean, you know, I guess a lot of costs have been shouldered by the balance sheets of companies at the moment. So do you think construction companies will be able to secure insurance for cover for the new issues they face?
Yeah, so there's a few related issues to unpick there. I mean, I think it is obviously true that the insurance market, like the rest of the world, has taken a bit of a battering, specifically in response to COVID, but also in the years leading up to it, as Bryn explained. And I think that there will undoubtedly be ebbs and flows in the market's willingness to cover specifically pandemics, but also particular categories of risk which have just eventuated in a big hard way. In the same way that you see ebbs and flows whenever in risk appetite, whenever a major risk eventuates. So the short answer to your first question is I wouldn't expect to see anyone offering cheap or particularly comprehensive cover for pandemics anytime soon, because that is a known risk with obvious and inevitable looking losses. But ultimately, one of the great advantages of Lloyd's is how fluid and dynamic and resilient it is. And I think there is a real extent to which policies can be tailor-made, crucially though, for those who are prepared and able to pay for them. So you may see some wider infectious diseases cover with strict sublimits, even in the sort of near to mid-term future, although I wouldn't expect to see cover specifically for COVID for quite some time longer. But insurance has only ever been one part of the picture in terms of mitigating risk. So I think, picking up on some of the themes that Bryn's already touched on, one of the key lessons that we can learn from the last 5 to 10 years is how to take a more careful and holistic approach to risk appreciation, evaluation and pricing for significant contracts. Now, you asked what next for companies looking for insurance. I mean, you and I have spoken about this before, and there are obviously two main aspects to that question. The first of which is pricing, and the second of which is scope of cover. So in terms of pricing, it's quite clear the market has been hardening for the past couple of years. I expect it to remain hard in the near term. The short answer is I agree with Bryn that premiums are likely to go up. In terms of the scope of your cover, I mean, the starting point always has to be think carefully about what you need, discuss this with your brokers, make sure you understand what your insurance covers and crucially what it does not cover. Because there are different categories of risks that people, contractors, employers don't necessarily think about before entering into major contracts. But by way of brief example, there's a lot of discussion about climate change, but I think we are still generally quite slow to factor that into our commercial thinking in any meaningful way. My experience is that significant and unusual weather events are becoming much more common in my cases. I had a case recently where a once-a-century flood had occurred twice in 4 years. But I'm not seeing many contracts which are actually factoring in those sorts of considerations, either in terms of the pricing for the job or in terms of thinking about the available cover to pick up the shortfall. For example, it's been a bit of a theme in some of my recent cases where contractors have had their works disrupted by adverse weather events. They then typically face two categories of problem. First, many standard form contracts will only allow them to treat extreme adverse weather events as relevant events, which entitle them to an EOT. And second, as you mentioned before, Damian, those events will entitle them to an EOT, but no additional cost. So you've got a situation where your contractor or your subcontractor is left to make up the shortfall. Getting cover for that kind of disruption in advance may well be prohibitively expensive, particularly for smaller contractors. So in those circumstances, where possible, you may want to try and preempt potential losses and thinking about how to rebalance the risks within the contract. And all of that will feed into the wider need by all parties to appreciate what risks are likely to apply and where they're likely to sit and who's going to pick up the bill at the end of the day.
Thanks, Athena. That leads me quite neatly into putting Bryn back under a little bit of pressure here now in that respect. And given the firm that you work with, Bryn, do you, and obviously on an international basis, do you think it is possible for construction contracts to correctly differentiate between commercial risks and policy risks? And then again, sorry, it's a two-part question. Do you expect us to see, or in fact, do you think it's more important than ever that more active communications in the tender and contract stages of projects between employers and contractors or contractors and subcontractors is entered into to ensure that the strict terms of the policy that is available and is provided are being adhered to?
Yeah, Thanks, Damian. I think the important part of your first question is correctly differentiated. I think that's a substantial challenge. Not only is unpicking the differences between commercial risks and policy risks notoriously difficult, and the subject to a number of disputes, some of which I have on my desk at the moment, but the motivation of the employer to engage in this process has to be questioned. It is, of course, a relatively simple drafting exercise to differentiate between, say, insured and uninsured losses in those broad categories, and to differentiate between the respective treatment of them. In some circumstances, this can be done relatively easily, and there will be commercial grounds for doing so. However, uninsured losses cover a multitude of risks and issues. So can this subcategory be easily differentiated? Does an employer have an appetite to treat, say, the workmanship errors of its contractor differently from the lack of cover available for fire safety issues for which there's no or limited cover? On the one hand, these could be neatly differentiated in our minds because a contractor has control over his workmanship, can strive to ensure it has delivered the works as they should be. However, a contractor has no control over the availability of insurance for fire safety. But from an employer's perspective, is there a difference? And do they really care? Doesn't the employer want to have a right of recourse no matter what? Perhaps this right of recourse is worthless, particularly in the absence of insurance. But the employer wants to ensure that the contractor is incentivized to deliver the works appropriately. And maybe the only way to do that is to keep them on the hook contractually. Turning to the aspect of the question relating to whether there should be more active communications, I 100% think that that's so important. The cynic in me is a little bit doubtful that we're going to see a step change in approach. The pragmatist in me is a little more hopeful. The ability to insure, to me, seems to be a relatively long lost motivation for the allocation of risks at the contractual stage. If the intention is to ensure that the employer has the benefit of access to a contractor or consultant's insurance cover, it only makes sense for the terms of the appointment to be drafted in a way that will not immediately vitiate that cover. Or, to the extent it can be catered for, place the contractor in a position where its potential liability is inherently made up of matters that will be difficult to untangle between insured and uninsured losses. That's a lot easier said than done, but the reality is it becomes timely and costly to untangle. Terrible for everybody. However, it's plain that the employer is not always in a better position than the supply chain to obtain insurance. More often than not, though, there are a range of insurance products that are available for these purposes. For instance, take the NHBC type insurance products, to which I obviously have to add a disclaimer that there are other reputable providers of this type of product. These products are, in many instances, responding in relation to the cost of remedial works relating to faulty cladding, so very topical. This is one of a number of potentially responding policies, but often it is the one that has the least complications in demonstrating the loss is insured. That does not, sadly, prevent a subrogated claim against the supply chain from the NHBC or other insurer. However, that will be the subject to the terms and conditions of the appointment, which might have limited the rights of recourse that the employer's insurers has against the supply chain, a proper allocation of the risk. Now, subject to the terms and conditions of the employer's insurance, this is all entirely acceptable and might represent a better way of allocation of the risk between the employer and the supply chain. Does that answer your question?
It does, yeah. I mean, it's well, it answers it. I mean, it was a fantastic answer, and obviously, in terms of disentangling and the expertise required, I mean, obviously that must be quite fearful for a number of subcontractors, contractors, and employers alike. So I think the issue of the communications, yes, it's definitely required, but obviously there's a required level of expertise in there just to ensure that the understanding of what those words say and the strict terms say gives both parties what they expect it to be given them. So yeah, I think it's a real challenge for the future, and one that will get poured over significantly, I think. Athena, I just may bring you back in now. Then obviously we talk about the natural conclusion of these issues is brought about by greater transparency and understanding. And obviously the understanding, as Bryn's explained there, you know, me listening to Bryn there, you know, I got some understanding, but not the same level as Bryn has. And probably the employer may have when they are advised by a law firm such as Bryn's practice. The transparency and understanding, it's there to ensure that the risks to be included in policies are allocated correctly. And that's something we always talk about in the contract industry, that, you know, if the employer is the best place to shoulder the risk, then he should actually shoulder the risk. If that can be managed, can a contract ensure that those issues are strictly observed? I mean, I'm not quite sure of the answer to this question myself, but I'm just trying to understand that we open this up to transparency and understanding to make sure that risks are covered in policies and they're allocated correctly. But how do we manage that under a contract process? How do we make sure that's actually completed?
I mean, piggybacking on points that Bryn raised, I think your problem first and foremost is commercial rather than a question about drafting, because I think you would need to get buy-in from both parties to some quite difficult conclusions in order to be able to express them with sufficient clarity that you don't worry about how that's going to be construed further down the line. So I think there is a tension necessarily between commercial pragmatism and frankly, the clout that many employers will have on more significant projects. I mean, I think it's also inevitable that projects will become more expensive if a greater range of risks are envisaged and encompassed as part and parcel of the works. I suppose as they become more expensive, the more likely you are to employ firms like Clyde & Co. to advise you on those risks and to help you ensure that the contract delineates and sets out those risks in the way in which they've been agreed, which hopefully puts you in the best possible position to ensure that if those risks eventuate, you're following an agreed contractual pathway to resolve the issues that arise.
Bryn, I mean, obviously, Athena gave you a nice plug there as well.
Yeah, I was going to say, thanks very much.
Well, I mean, obviously, if you work, just for instance, if you're working employer side, what do you expect the attitude of the employers that you work with on projects to be if they're faced with having to accept greater risk and increased costs on their projects? And then that's my first question. And then I still wanted to come back to that negligence point that we talked about a little bit earlier. If costs increase for employers, do you think that will perpetuate an increase in claims against design professionals based on an allegation of negligence, i.e., you know, they missed out the culvert under the road, which caused an extensive extension of time and costs? Do you think that become part of a commercial strategy to ensure that employers stay within the ambit of the original budget?
Okay, so attitude of employers, in a word, aggressive. Who enjoys paying more for less?
Yeah.
However, that is essentially the reality that purchasers of insurance face. Employers cannot be blind to the circumstances of those with whom they contract to provide the service. I think the answer, to an extent, lies in the education of employers, and perhaps even more so, in my opinion, the funders, as they have the ability to really insist on and facilitate institutional change. That education can come from the contracting market, but also from those who advise the employers and the funders. Reallocating risk from a contractor to an employer, to the extent that it is insurable, can be seen as even then be seen as suboptimal, but it can also be seen as providing the best protection for the employer. What's the point of persevering with the status quo if it leads to uninsured claims against a contractor or a consultant that's unable to meet those losses? In many instances, this also leads to protracted and lengthy disputes, because if the losses are large enough so as to threaten a contractor or a consultant's viability, all funds get thrown into fighting that dispute. It's make or break. So as with all things, I think the answer is to be found in balance, balancing the reallocation of the risk and ensuring the losses with suitable commercial terms to make the project viable, but also to reflect the reallocation that's taken place. Why should employers pay for cover that they're no longer securing for the contractor because it's not available? If the employer is taking out that cover, should those costs or some of them be reflected in the contract value as a quid pro quo? If risks are reallocated in this way, these can be reflected in the contractor's premium as well. If contractors aren't exposed to these losses, they've been reallocated via the employer's premium, then professional indemnity premiums can come down. In relation to claims against design professionals, and whether we'll see more of those to make project viability. I mean, I think the starting point for that is employers stop that. No one ever recovers all their losses, and I think their starting point will be to pay what needs to be done in order to complete the project without having any issues and problems and losses and claims arising therefrom. But will we see more claims against consultants? Perhaps. I mean, claims against consultants is not a new phenomenon, and it's one that is more common when macroeconomic conditions provide circumstances that see many contractors no longer being financially viable. Yeah. There's obviously been an increase in these of these types of claims in recent years. In part, in my view, this is skewed by Grenfell considerations, because latent defects have only been discovered outside of contractual limitation periods. So employers who are looking for a home for the losses are looking perhaps to tortious duties owed by consultants to provide them with an in-time cause of action. That's an easier argument against a consultant than it is against a contractor. So in addition, the general insolvency issue and the size of claims drives the approach in relation to claims against consultants. I'll give you an example. I've seen a claim against a structural engineer arising from the fire safety of external cladding. Now, structural engineer and the design of the external wall is not a natural connection. However, where there's a need, that claim was pleaded in excess of £60 million because of substantial decant costs. And the scope of the appointment permits an arguable case, then I see employers chancing their arm a bit more. The difference in the duty of care that a consultant and a contractor owes has to be borne in mind in this context, though. So the former are subject to reasonable skill and care obligations, whereas contractors are required to deliver a project that's fit for purpose. In the cladding context, we've seen numerous reasonable skill and care arguments run by consultants. You know, we were doing what everyone else were doing, so we've met the threshold. This is an argument that contractors can rarely raise. So claims against consultants are harder. Cost risks have to be borne in mind too, as bad claims can rebound on claimants. But I think many employers take the view that if insurers are involved, they'll contribute something in order to manage their risk to the claim and irrecoverable costs.
Thanks very much, Bryn. If it's okay with you both now, I mean, I have more questions to ask you, but I'd like to take some audience questions. And maybe, Bryn, if you could just consider the question from Uwe, but I'll turn to Athena first. And Ian McElway asks, is the market for PI strained or broken? Do we need to look beyond the traditional and consider alternatives such as integrated project insurance that drive better collaboration rather than contractual risk mitigation?
I would describe the market as hard. I don't think I'd describe it as broken. I think it is still, generally speaking, possible to get cover for a huge range of different risks, as we discussed. However, the question is whether or not you're able and willing to pay for it. I understand why people might look to alternative forms of sort of risk covering, or alternative risk covering products, essentially, in circumstances where they can't find what they want at a price which they can afford to pay in a traditional marketplace. And I think that the more that contractors, employers, or whoever turns to alternative products, the more likely it is that we will see a softening of the traditional markets.
Do you think in turning to alternatives, do you think there'll be a plethora of legal test cases following in that situation? Or, I mean, at the moment we know something from the Allianz case, and you mentioned the other case as well. I mean, if we go to alternative solutions, do you think we'll end up with a whole series of new test cases? Or?
I would expect so. I mean, this is the major disadvantage of novel forms of anything, novel forms of technology, novel forms of legal protection, novel forms of contract. There are unknowns. There's no certainty as to how they will operate. There's no certainty as to how the courts will treat them. So to an extent, with a traditional product, you are buying a degree of certainty as to how certain clauses are likely to play out. You can speak to your broker and get that confirmation, that assurance. But there's a long line of cases that says that if risk X eventuates in the following way, you will be paid out some Y. There's never 100% certainty in anything. It's always open to challenge. There's always the possibility you will get a judge who disagrees, or that you will have some peculiar freak incident which prompts a different outcome in your case. But we're playing with marginal risks here. at the end of the day, you will have more certainty about the operation of traditional products within traditional parameters than you will with newer risk-based products.
So almost better the devil you know, to some extent. Bryn, there's a couple of questions for you, really. We can do them both in turn. And Andrew Cook has asked, Bryn, is there any variance in premium uplift for PI cover depending on the sector in which the consultant works? For example, building, construction versus civil engineering versus process, i.e. oil and gas, or is it a blanket increase?
Yeah, so disclaimer, I'm a lawyer, not an underwriter, but I would.
Underwriters.
I mean, Athena touched on it at the start. You know, the reality is, you know, the Lloyd's market is very agile and respond. And Damian, you spoke to it as well. It will respond to individual risks. So the risk profile of any specific consultant, and that includes their risk management processes, their claims history, and the sectors that they work in, will be factored into their premium. But what I would say is there is a general upward trend of professional indemnity premium. So assuming all things being equal, there's been no change in the risk from 5 years ago to today. You will be paying substantially more money. That is to do with certain economic factors, but also reflecting the fact that 5 years ago, the market was underpricing insurance, generally speaking, and Lloyd's has said, you can't do this, this is not sustainable. Insurers are going to go out of business.
Maybe just before we turn to the second question from Uwe, I can bring Athena back in on that same topic. And this is one of the questions that I had, and I was considering, not that I particularly work in this sector, but in Athena, in the aftermath of Grenfell, obviously professionals, designers are now facing the prospect of defending claims for their use or design or specification on cladding on other buildings not yet under scrutiny. So, you know, where thankfully there's been no further tragedies. But does this mean that they must consider how they will deal with works that they are yet to even start in their insurance policies?
You mean sort of pragmatically, commercially, or as a matter of law? Because I was going to say, I mean, I think as a matter of good practice, if I were a contractor working in this sector, I would undoubtedly be thinking about my future liabilities and my future risks. It factors into what we were saying earlier about the need to have a more careful and holistic appreciation of risk. And unfortunately, that will take more time and expense. Where I thought you might be going with that was whether or not they would be able to get insurance in respect of known risks. And something I was going to say was, although I don't think you will be able to get cheap or comprehensive cover for known inevitable risks, in the event that you do find yourself in litigation, it may be possible to get after the event insurance in respect of, you know, your legal, the other side's legal costs, in the event that you have a particularly good claim. So there are different ways that you can look to find insurance or pockets of money to cover different risks as and when they eventuate.
Okay, that's very interesting. Okay, Bryn, Uwe in South Africa, where obviously I do quite a lot of work. Uwe said, in South Africa, we have had limited access to information at the Grenfell event. I recall an earlier report showed a typical floor plan with a corridor around the core with a lift and a single staircase, not permissible in South African building regulations, and that some tenants had enlarged their flat into the corridor, creating a dead-end passage, potentially cutting off the escape route to some tenants. The design team obviously has no control over what tenants do, but maybe property managers or the Residents Association must take responsibility. Maybe there's a question in there whether they should have insurance as well in terms of what they allow to happen on buildings once they become residential. Also, designers are generally guided by published safety criteria, which may not be correct, nor can designers spend sufficient time to monitor the correct installation by contractors. How can the designer be protected, having heard all the comments about PI insurance?
Okay, I mean, thanks for the question, Uwe. There's quite a lot in there. I think the easiest way for me to unpick this, Grenfell is an atypical situation in relation to the losses that flow from it, in relation to the more broad post-Grenfell insurance market claims we're seeing, i.e. it's one of the few places where a fire has actually occurred and people have actually lost their lives. And the reason why I differentiate between those losses and those scenarios is because there are different losses arising out of the cost of remediating a building that hasn't had a fire but has unsuitable cladding attached to it, and those where the building has actually burnt down and people have sadly died. So the reason why I say that is whatever is done internally within the building may well be the responsibility of the managing agents to ensure that tenants are complying with their terms and conditions of their lease, etc., and that the internal fire safety and safe routes of passage. But in the UK, number one, we have a stay put policy, generally speaking, which means that people don't leave their buildings, and that the buildings and compartments are supposed to be sufficiently fire safe so that you can be in there for a period that allows the fire service to treat the fire appropriately. But whatever happens in respect of a fire scenario and what happens on the internals of the building, that might be the responsibility of the managing agents, that has nothing to do with whether or not the external wall was sufficiently well designed or not, and permitted the rapid spread of the fire. So that becomes an issue of causation, who's responsible for a specific losses. But in terms of the actual external wall, the managing agents and whatever the tenants have done internally have very little connection to it. I raise that one small caveat to that, which arises out of the crossfire. That fire started because an interesting chap smoked a spliff on his balcony, and just as he was passing out, left it on top of the air conditioning unit. That is effectively why that fire started and spread so rapidly, in connection with the materials that were on that building. But that chap has no insurance and no ability to meet big losses, and that is another relevant factor in relation to the claims against consultants. If I can just come to the one aspect in terms of how can designers protect themselves, it is obviously meeting that reasonable skill and care test, or at least in the UK, it's meeting that reasonable skill and care test. It's doing what others in the industry deem to be suitable. And Uwe makes a very good point about the published safety of materials. Now, where those materials have published fire safety performances that are incorrect, and we know in the wake of the Grenfell Tower inquiry that there are materials which have been sold which do not meet their published fire safety criteria, then I think consultants have a reasonable skill and care argument. How are we to know? We followed the literature. But to give you an example that has also come out of the Grenfell Tower inquiry, a specific manufacturer of an insulation product involved on the Grenfell Tower held a traffic light system of people that would not use their products, people who would only use their products having asked substantial technical questions about the way in which they could be used and interfaced with other materials in the external wall, and others who wouldn't ask questions at all. Now, that, to me as a lawyer, speaks to reasonable skill and care. If some people are asking questions, or some people won't even buy the product because they just know that they're uncomfortable to use it with other materials above 18 meters, then that starts to give you a broader indication about reasonable skill and care.
Excellent. Hopefully that's helped you there, Uwe. I saw Prudence Walton, you had your hand up. I don't know whether you want to come on mic and ask a question just before we finalise today's proceedings. No, maybe not. Okay, maybe I can ask just one last question then, just to settle something in my mind then. Obviously, in terms of the insurance industry and the perils and the risks and what's included and what's not included, and this can be to both of you, if a business is facing potential third-party claims, is it correct or is it incorrect to assume that defence expenses will be paid in addition to the limits of the liability in the declarations? So, if somebody comes in from the left side and starts another claim against you, how protected are you under your policy on the initial declaration in respect of third-party costs and claims, or defence expenses against third-party claims?
So I'm happy to kick this one off, Athena. In relation to defence costs and their response to third-party claims, it depends on a number of factors. I should start that the very much the usual position is that defence costs are indemnified in relation to a third party claim, are indemnified under a professional indemnity policy. But you have to account for policy response. So does the policy respond to the third party claim? If not, defence costs don't follow. A slight nuance of that issue is there a mix of insured and uninsured losses, i.e. does the third party claim include both elements to which the policy does respond to and elements that it doesn't? Generally speaking, insurers will only indemnify defence costs incurred in defending the insured losses. I regularly have to deal with apportionment of my costs between insured and uninsured elements. Now that can be done as a matter of a proportion of my fees agreed up front, or you can try and allocate those costs against specific issues, but it's not always easily done. You also have to consider cost inclusive excesses and limits of indemnity. Defence costs get paid out first, even when it's an insured loss. Contractors regularly have defence costs inclusive excesses, although consultants rarely do. And this often leaves the defence costs as, in effect, an uninsured loss. Now, that's often netted off against the indemnity of the claim that insurers pay, but that's subject, obviously, to the extent of the liability and the size of the excess. Now, defence cost inclusive limits are very much rarer things. So normally, that doesn't come into play.
Thanks, Bryn. Athena, you opened up for us, so maybe you can close off for us. Have you got?
I know that was a really comprehensive answer from Bryn, so I don't have a great deal to add to that. I think I'd just say always check your policy, don't assume, but as a general rule, yes.
Yeah.
Yes is sometimes the easiest answer, or the best answer as well. Well, thank you both very much. We don't have any further questions, although I'm sure we could talk for a considerable time longer, just opening this discussion up. Obviously, it seems quite unusual in times where you can get insurance for a car that drives itself. There are lots of challenges for the construction industry to deal with over the coming years. But as I say, it's been an absolute pleasure to have you both with me today. Thank you for your time. I know that your time is valuable. You've given some fantastic answers and a great deal of education as well in terms of what you've allowed our audience and myself to understand. So very much thank you for your thoughts and opinions today. The spotlight will be available on our YouTube site. So some of those cases that Athena did talk to can be picked up in the recording there. And you can also see some of our previous spotlights. But thank you to everyone for joining us today. I look forward to seeing you again at our next spotlight, which will be in September after we've all had a well-earned summer holiday. Thank you very much.
Thanks, Damian.
Cheers, Ben. Thank you. Thank you, Athena.
Bye.